facts and verified by oath, be removed before trial into the next Circuit Court of the United States to be held in the district where it is pending. This act plainly has reference to sections 1977 and 1978 of the statutes which partially enumerate the rights and immunities intended to be guaranteed by the Constitution. The first of which declares that all persons within the jurisdiction of the United States shall have the same right in every state and territory to make and enforce contracts, to sue, be parties, give evidence, and to the full and equal benefit of all laws and proceedings for the security of persons and property, as is enjoyed by white citizens, and shall be subject to like punishment, pains, penalties, taxes, licenses, and exactions of every kind, and to no other. This act puts in the form of a statute what had been substantially ordained by the constitutional amendment. It was a step towards enforcing the constitutional provisions. Section 641 was an advanced step, fully warranted, we think, by the 5th section of the 14th Amendment. We have heretofore considered and affirmed the constitutional power of Congress to authorize the removal from state courts into the circuit courts of the United States before trial of criminal prosecutions for alleged offenses against the laws of the state, when the defense presents a federal question or when a right under the federal Constitution or laws is involved. It is unnecessary now to repeat what we there said, that the petition of the plaintiff in error, filed by him in the state court before the trial of his case, made a case for removal into the federal circuit court under section 641, is very plain. If, by the constitutional amendment and section 1977 of the revised statutes, he was entitled to immunity from discrimination against him in the selection of jurors because of their color, as we have endeavored to show that he was. It set forth sufficient facts to exhibit a denial of that immunity and a denial by the statute law of the state. There was error, therefore, in proceeding to the trial of the indictment against him after his petition was filed, as also in overruling his challenge to the array of the jury and in refusing to quash the panel. The judgment of the Supreme Court of West Virginia will be reversed and the case remitted with instructions to reverse the judgment of the Circuit Court of Ohio County, and it is so ordered. End of Strauder v. West Virginia, an opinion of the United States Supreme Court.